3 people get arrested. 3 judges worth of paperwork says there's enough evidence to hold them. And in front of Judge David Flecher in Harris County, all 3 walk out the same day. This is a probable cause hearing the first checkpoint after a warrantless arrest, required under Article 15.17 of the Texas Code of Criminal Procedure, where a judge has to decide whether what police actually wrote down is enough to keep someone locked up. Case 1, Raquel Rodriguez, charged with driving while intoxicated after a traffic stop on October 28th, 2024.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the DIMS, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1-leg stand. He also noticed that I think she took off her boots for the 1-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right. Please take a seat.
Judge Flecher's problem wasn't the traffic stop itself. Speeding is a valid reason to pull someone over. It's what happened after. Field sobriety testing extends a stop. And to justify that extension, an officer needs reasonable suspicion of intoxication, not just a routine traffic violation. Here, all the officer had was an odor of alcohol and Rodriguez's own statement that she'd had 2 drinks 2 hours before she was pulled over. Under Article 38.23 of the Texas Code of Criminal Procedure, evidence gathered by extending a stop without that reasonable suspicion can't be used against the defendant. Take away the field sobriety results, and there's nothing left to support the arrest. The state dismissed the charge in February. The next hearing happened the same day as Rodriguez's Keon Shaw, charged with fleeing a police officer after a traffic stop that, according to the officer's own report, escalated fast.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
I know probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, you know, trouble on your life, all right?
Yes, sir.
All right, man, good luck.
Asking your honor is Mr. Francisco Cerda. He's a custody judge, and I wonder if I'm wrong on this.
Is that C or an S?
The teacher, the RDA. Oh, he's right here.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
Judge, my concern is, if you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge,
and
and
they've given a description of a tall, lanky person,
yeah,
right?
yes, Judge, and respectfully, we defer to the court because all it says in the DIMS is that the defendant Serta remained in the U-Haul. There's no further information regarding Serta.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your
what
Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We have to await the OR, and we don't have that at this time. So-
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. and we have to
No,
decide.
he's in custody, and I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay, all right, for sure.
Being in the wrong vehicle at the wrong time isn't the same as being part of a criminal combination, and that distinction is exactly what organized criminal activity charges require. In the 2000 case Munoz versus State, the Amarillo Court of Appeals held that this charge demands proof of an ongoing agreement to commit crimes together over time, not just presence during one single episode. Here, the entire case against Serta was that he was sitting in a stolen U-Haul. Nothing tied him to a broader pattern, nothing showed an agreement to keep offending together. Judge Flecher found no probable cause, and the charge was dismissed. 3 hearings, 3 dismissals, and in every one of them, the gap wasn't whether something bad happened, it's whether the paperwork in front of the judge actually proved who did it. That's the entire point of this hearing existing in the first place, to catch the difference between an arrest and evidence, before someone sits in jail for the space between them.